If you cut a cucumber in half, strap it onto a tree, and fill a cup with soil. This is a branch from a lemon tree that's been growing for years. We mark about 2 inches above and below the spot. Ring cut on both sides, then a vertical cut to connect it. Bark comes off easily. Then we scrape the cambium layer. This stops nutrient flow completely. Next, take a cucumber. Cut both ends off. Slice it in half. Carve out a groove in the center to fit the trunk. Clamp it onto the cut area. Secure it with toothpicks. Take a plastic cup. Cut it open in the middle. Wrap it around the cucumber and tape it. Fill it with coconut coir, or garden soil if you don't have it. Press it down firmly. Water it well. Then cover it with a black plastic bag to keep it warm and humid. 40 days later, we remove the black plastic bag, and something unexpected happened. The cup is full of roots. The cucumber is no longer visible as before. Cut below the roots. This becomes a new plant. This method lets fruit trees skip the whole seed growing stage. The new plant already comes with roots and leaves, and it keeps the good genetics from the parent tree. After planting, it usually fruits much faster. This technique is called air layering, and it works on most woody plants. Follow for more interesting growing tips. What happened?
Fried apple pie. Let's get it. Now check this out. Look, now that I got them cut down, it's up to you guys how you want to do them. You know what I mean? I just go ahead and do them like this. You know what I mean? Then we just kind of like, the objective is to like just, I guess it would be, the principle would be like just cutting them and getting them into cubes like this. And then you just want to go ahead, throw them in the pot, and then you just want to repeat. Okay, so look, here we go. You guys can see, got it all, you know, diced out, right? So now I'm gonna start with, I'm gonna do it like this. We're just gonna go ahead and get 6 tablespoons, right? I'm not finna like pack it in and do nothing like that. That's 1. And check it out. For the sake of argument, this is camera magic, 6. Okay, so look, you know, we just put in that brown sugar, right? So I'm gonna go ahead and get myself a medium flame. We got that going because we're gonna start heating it up, right? Now we're gonna take our, you know, our seasonings here. Boom, we're gonna put them in right there. Now, you're just probably gonna go about 6 to 8 minutes. Depends on how many apples you put in here, how big your cubes are and all of that. But that brown sugar, look, it's starting to turn into some magic. And if it don't smell like fall, for me, it really smells like, you know what I mean, that old school apple pie. Okay, so look, while we cooking the, you know, the apples down, you know what I mean? We're gonna go ahead and open this up. Remember, gotta be thawed out, right? Go ahead, pull that out. Look, I'm gonna open this up. You see it's got that flour on it, so none of it stick. And then they put this in here. It's a reason. I didn't have to put nothing down on my board. It's up to you how you want to do this. It depends on how big you want your, you know, your apple pie to be. If I want it to be the same size as this box, check it out. You know what I mean? So I'd probably look at it this way and then just roll it over this way and figure that's where it's going to be, right? So I'm going to go ahead and just take it like this, right? And just cut this down like that. And then I figure here, that look good. And then here, right? So we just cut them down like this. Real simple. This right here, you can fold this up, roll this back out, and make yourself something else. To be honest with you, I'm going to fold this up like this. Mash this around, hit it like that, and I'm gonna make something myself, folks. Loving it. They nice and soft. I got myself a toothpick, check them out just to make sure that they, to my liking. Now I'm gonna go ahead and just take 2 tablespoons of butter. We're gonna drop that in just like that. Hey, I know what's happening right now. I know y'all like, ooh, All of our butter has already melted, as you can see. Now, if you take a look, just get the bowl. Look, you take your cornstarch. Just go ahead, put that in there. Look, we want to do equal parts. And it's cold water, right? So we got equal parts of cornstarch. Now I'll do water. Cold water, that is. Now we'll add it, the equal part of the cold water. Okay, so then all we do is we just pour it in while it's nice and hot. Look, this is going to be our thickener, ain't it? You could just see the magic happen right in front of you. You know what I mean? Look at this right here. Look at that. Can you see it? Let's see if we can get it to come off with the spatula. Ah, yeah. That's what we're looking for, folks. And it's nice and soft. You know what I mean? This is where it still has some integrity. You guys make it the way you would like to. Some people might want to have a lot of crunch. Some want to be in between. For me, I like the in between. But this right here is what we're going to put in the inside. Ooh, we got the filling done and all of that, right? So look, what you're going to need is you're going to need yourself a fork and you're going to need a spoon. Reason I got the spoon, look, I'm going to just go ahead and just get down and make it happen. By now, I'm sure all of y'all have already tasted that. Yes, sir. Thank me. This is the McDonald's, apple pie. So now you know that this is exactly what they did when they made it. And when I say the taste is right there on point, that's it right there. But it's real simple. This is how Granny apple pie used to taste anyway. This is what you want to do. You want to get yourself a good bowl, get your little water. We're going to work with our fingers now. So check it out. We just finna take this and we just finna wet these edges, right? And then you look, again, this is where it starts becoming self-explanatory. Look how I do this right here. I just put this on the top, just like this, and then I press down my edges. Now we bring that fork in, and look, we just put a little indentation, and it presses it in. So notice, I just go out, I'll go down, and then out. Down, and then out. Down, and then out. You guys get the message now. I can leave it like this. It just shows that if you guys fold them over, you wouldn't have to do all 4. But since I cut 2 separate pieces, we're going to go ahead and just get it mashed in like this. Now we just get a spatula and we just go ahead and just put it down. Now just get yourself a spatula, right? I got some parchment paper on a tray. And what we'll do is we just slide it off, right there. All right, so you guys can see this is what they look like. Got the hump, got the look, everything, right? Now this part right here is key. Listen, we want to put these in the freezer. We're going to put them in there just for 20 minutes. You want to get them nice and firm. So that way when we drop them in this hot grease, we'll get that, we don't want them to just overcook. So remember, 20 minutes. Okay, so look, we just come out of the freezer, right? Here we go. They looking ready. And you can tell they've been in there because you can see how rigid they are, right? We just going to go ahead and take them and just drop them in here just like this. Real simple. So look, I got myself my wooden spoon, right? What I'm doing is I just make sure in the very beginning process that they don't stick together, right? So I just keep them separate. And now you can just see. Oh, and then let me say this part too. This is only about 3 inches of oil. You know what I mean? 2 to 3 inches is all you need. Okay, so for those of you guys that do remember the fried apple pie, right? Or should I put it out here like that? Hey, check it out. Fried apple pie. Hey, not for real. Listen, now we got our our sugar. Look, all you do is add your cinnamon, get your whisk, and we just whisk it together. This right here, this should take you back because this is what's on the top. You know what I mean? And when they completely, look, this is how we're going to do this. When they come out, before they even, drip dry with all of the oil, you know what I mean? We want to go ahead and sprinkle some of this goodness on top of there. And that there, folks, when they cool, we finna eat. I got to tell you guys this part two. Look, we just cooked to the color. You see how this is right here? Oh my goodness. Cheers, folks.
Was a school designed to train people into the religion called ministers in order to study the Bible, in order to spread the truth of the Bible. Now, Harvard then would encourage the development of other universities, Yale, Princeton, okay? And collectively, they would be known as the Ivy League. But over time, as America became more wealthy, it became also less religious. And so the Ivy League became social clubs. These were just places where the rich of America went to become friends. So these guys did not study. They drank, they dressed up like girls, they had wild parties, they played football, they took risks. They became good friends and they went on to become the leaders of America. If you were rich, you went to these social clubs called the Ivy League. If you think about it, over time, they become less and less relevant. Because just because you're rich doesn't mean you're smart. All the smart people are going to Chicago and Johns Hopkins. And so over time, we can expect Chicago and Johns Hopkins to overtake the Ivy League. Okay? And that's why Harvard decided to institute scholarship programs. So they wanted more smart people into campus, okay? And this created something called the SAT. Okay, this is the origin of the SAT. The SAT was founded as a scholarship program to identify the best and brightest students from all over America so that they could come to Harvard and help Harvard be the best university in the world. Before, their kids could just go to Harvard and have a great time. Now it's hard for them to get in, they have to take a test, and also they're in class with smarter people. On one hand, it wants the best students in America, but on the other hand, it still wants to maintain good relations with its alumni. So that's why it created a new system. Now it's focused on holistic, specifically character. Just being smart is not good enough. You have to be a good person. But this word was created to basically keep Jews out, okay? We need people who are manly, who are strong, who are brave. We need white people. And that's why we have the system that we have today, where it's not just test scores, it's essays, it's transcript, it's teacher recommendations, because they want to identify the Jews and keep them out, okay? The purpose of all these changes is to ensure that Harvard remains the institution of power in America. Harvard's not interested in academics, it's interested in power. Therefore, it must ensure that the people who come to Harvard are the ones who are most likely to succeed. You can be the best student in the world. They don't care. If they don't like you, they'll just say, we don't want you, okay? From Harvard's perspective, best just means the most likely to succeed. So the majority of students are still students who will be successful no matter what. Why? Because their families are rich. You let in the child who comes from 3 generations of Harvard graduates, okay? And that's the majority of people who get into Harvard. And then you let in the athlete, okay? So the athlete, the legacy, these are the people who are the majority. And then you have like 1% of positions for people like me, who you don't really know, but there's potential there, so let's take a risk. On an essay, you just wrote something really interesting, and they laugh. And it's like, okay, let's take a chance on this guy. They have that 1% of positions available for risk, okay? This system, the meritocracy, the way it's set up, it creates trauma, okay? So let me explain why. So let's look at university, Yale, then we'll look at high school, okay? Then we'll look at parenting, okay? So you think, oh, you're getting to Yale, you can just coast, you're happy, life is simple, okay? The fact of the matter is that when you get to Yale, Yale is actually the Hunger Games. Have you read the book, The Hunger Games? It is a relentless competition. Because once you're in Yale, you're still competing. But now you're competing against the most competitive people in the world, okay? So maybe at the school, you can be the best student. Your parents love you. You have lots of good friends. You have student government. You feel really good about yourself. You go to Yale, and then you recognize that you're a nobody. Your parents are far away. And you're now in competition with the best students from all around the world who all want to kill you because it's a zero-sum game, okay? Only the strongest survive. Outside the classroom, you're competing to get into clubs and something called secret societies, okay? But you're also competing for graduate school, for law school, for medical school, for scholarships like the Rhodes Scholarship, okay? So Yale, it sounds nice. Once you get in there, from the first day, it's an endless pursuit of achievement. It's just competition after competition after competition. Wherever you go, you're being judged by someone, okay? You're being judged by the professor or your classmates, and everyone's looking to like basically kill each other. So this is very traumatic. And it makes you so insecure that you go through life thinking like life is just like that. Everyone's an enemy. I have to achieve in order to feel good about myself. Harvard was a school designed to train.
Sheesh. That's a motherfucker right there. Get in there. What did I tell you? All secrets shall be revealed, right? Black Americans, we can't keep our behind out of trouble. to save our life, right? So, in case you've been hiding under a rock, Dr. Hazid Hawass, right? He had made a claim about us years ago, and I'm about to show you what he said, right? I'm about to show you what he said, but then I'm about to show you a screenshot and the blood sample that refute his claims of what he said about us. All secrets shall be revealed. Now, before I continue, if you'd like to donate $1, I greatly appreciate it. Now, check this out. Yes, Zaid Hawass, a former Egyptian minister of antiquities, has refuted, that means not claim whatever, the claim that the ancient Egyptians were American Negroes, right? Why is he talking about us? What did we do to him? This article is very old. Why did he mention? We just started talking about this a couple of years ago when we woke up. But why is you mentioning us, right? Arguing that such claims are based on false history. False history, right? Well, check this out. In the Egyptian tombs over there in Egypt, they found a 5,000-year-old map of America discovered in Egypt revealed terrifying secrets. What secret does it reveal? What secret does it reveal? Watch this. Now, you can read all of this. I'm going to let you read all of this. You can go ahead and read all of this. But let's continue. Some African Americans have this.
What happened? Shit froze up. There you go.
Man, get in here, get in here, get in here. What did I tell you? All secret. I'm going to let you read all of this. You can go ahead and read all of this. But let's continue. Some African Americans have discovered that there are descendants from Egyptian pharaohs through DNA testing, right? Troy Williams, Dexter Coffey, Robert King Davis Ross. Hold up. I thought you said Azid Hawass that is not American Negro. But what happened? We took a blood test, right? And then in a secret meeting, right, over there in Egypt, the Negro skull was slightly larger than the Egyptian skull. But upon study, the skull found the serving class in Egypt. He found the Negro in America to be an exact match. Did you hear that? Did you catch that? Did you catch that? Ha! All secrets shall be revealed.
These treaties that established their legitimacy. These tribes signed their peace treaties with the King of England. The principal one was in 1677 with Charles II. It's been recognized for 332 years, both in Virginia and in England. So there's a uniqueness because they date all the way back, as both the governor and senator have said, to when the English settlers arrived on the shores of Virginia. We were hoping we could get this done by the 400th anniversary of Jamestown. We missed it, but we can't give up on it. But the second reason is it goes to a very shameful part of Virginia's history. There was a paper genocide that occurred. The officials in Virginia deliberately expunged the records. They destroyed the official records and most of the private records. I've got a statement that gets into the whole thing, but basically, a lot of Virginia's ruling elite claimed to be blood descendants of Pocahontas, and in their view, that meant that no one else in Virginia could make a claim that they were Native American, a descendant of Pocahontas, because to do so would mean that Virginia's ruling elite would have to be classified as all other non-whites were, which was, in quotes, and this was the law, the inferior Negroid race. This was what it was about. And with enormous hypocrisy, Virginia's ruling elite pushed policies, got them passed, and it culminated with the Racial Integrity Act of 1924. They signed these peace treaties that established their legitimacy. These tribes signed their peace treaties with the King of England. The principal one was in 1677 with Charles II. It's been
the land right now are not members of the Winnemucca Indian Colony and cannot trace their lineage back.
They boarded up some houses, bulldozed others, saying they were unsanitary and unsafe in some cases, and they paid to have some mobile homes moved.
But anybody that returned to their residence after that were arrested by the Bureau of Indian Affairs.
Kyle, Missouri spent 6 days in jail after he tried to go back to his grandmother's boarded up house where he also lived. A giant fence around the colony's homes, and the court order keeps evicted residents out. It crushed me.
Nationally, thousands of tribal members have been banished over so-called lineage concerns. But it's not that simple. Other tribes are accused of ousting members.
Our ancestral name wasn't listed on a colonial document from 1942. That's the main excuse that they're using, that we're not indigenous.
Rebang has lost her tribal benefits, and so have the elders. Back at the dinner table, Aldridge and her husband face eviction.
I'm not convinced this tribe will ever be the same or will ever be a tribe again.
I'm Native American, and that's what I am.
Armed tribal police are caught on camera serving eviction notices.
And before y'all scream, oh, native erasure, oh, native erasure, one, native means foreigner. That's just someone that comes to a landmass and lives on that landmass. That does not mean that they are the original people of that landmass. See, they like to make it seem like when they came from Asia, these lands had no one on them. But I'm going to tell y'all, these lands always had people that look like me. And we are in the Library of Congress. So you can look at my ancestors. For me, Aboriginal Australians and Melanesians were the first Americans, and those are Negroid people. So I don't care how dark the Native Americans was back then. I don't care about none of that. When they came here, they met us, and they are not the original people. That's why these evictions are happening.
They was able to get in on. They was able to get in on the. They was able to create. It was able to create these.
You know that you have to pay $450 to file a lawsuit in the United States federal court. Did you know that if you want to appeal to the United States Court of Appeals for the Second Circuit, it costs $650? Do you realize that they're charging the American citizens for justice? This is treason. Did you know that you have to pay $450 to file a lawsuit in the United States federal court? Did you know that if you want to appeal to the United States Court of Appeals for the Second Circuit, it costs $650? Do you realize that they're charging the American citizens for justice? This is treason. Did you know that you have to pay $450 to file a lawsuit?
Mm-hmm.
They use Pocahontas as like
Be a state inside of a state.
the main,
Be a nation within a nation. Be a country within a country.
like she was
A parallel structure, a parallel system, a parallel economy. Why, in this day and age, you could even think about a parallel black currency
Like a lot of them
in the United States. That could even become global.
take DNA tests.
Like I said, the proof that you can build is already in your inheritance. Greenwood is the proof. Wilmington is the proof. The UNIA is the proof. The Black Panthers is the proof. MOVE is the proof.
They don't look
You
like
understand?
Yeah, they don't look like Indians.
Every single one of those projects demonstrates capacity, remarkable capacity that American empire and the white power structure could not match and could only destroy by force only. You come from a people who build things. You come from a people who built those things. You have that in your genes. You have that in your inheritance. You have the proof of concept already in hand, in more favorable conditions than those under which they accomplished what they accomplished. What, for example, your grandmother accomplished. Do you understand? They had the plan, they had the initiative back then, but they didn't have the conditions for success. Now you have the conditions. So do you have the plan? Do you have the initiative?
That's why they
See, that's why they want you to have the destruction of those past initiatives uppermost in your minds. Why they want you to only remember the burning of Black Wall Street. That's why they want you to give up the idea of building before you even start, because now in 2026, they know that they can't stop you if you start. The question again is not can you, the question is will you? The question is whether your generation, sitting at the front end of an era of decentralization, that in my opinion, future historians are going to study as one of the greatest civilizational openings of the modern era. Whether or not your generation has the imagination, has the discipline, and has the courage to do what your great-grandparents already proved was possible to do. And for you to do it under conditions today in which the white power structure that destroyed them is no longer in any sort of a position to destroy you. I'm telling you, be a state inside of a state. Be a nation within a nation.
All right. So, so what we're going to do is we're going to go back to the status conversation, and we will start with the video. Let's remove this real quick. Let me get this back up. Let's get that. All right, boom. Boom. All right. So what we're going to do is going to get this back up. We're going to go here to this thing. Appreciate everybody being here who was here. We're going to move this along to status. Let's see, 107. 110.
That's all you have to ask. Okay. When I gave that talk in church, I was removed from the stand, hauled to the bishop's office, talked to, and I never went back. Runs all the tellers. She's the bank president. She handles all the bonds. The federal courts buy all the state bonds. So everything that happens runs all the tellers. Any court clerks. What do they need? This building covers an entire court clerks. What do they need? Just in courtroom service has he's 5-story. The federal court clerks. If you look at Portland, Oregon's building that pretty much Antifa destroyed, the federal courthouse in Portland, but it's a 5-story building with 2 more stories below ground. Okay. Judge Mosman, he's no longer there, but he had the top 4, him and his aides. U.S. Marshal Service has a bottom 4 down in the basement. That's the marshals. Then there's 2 more floors of judges and courtrooms, 2 floors. All the rest of this building are court clerks. Court clerks. Why do they need hundreds? I mean, they're in cubicles.
What's going on, David? And put the link in the chat. We're gonna be short today. Short, but not in stature. But yeah, we're gonna do that. Boom. I need to find the.
Why do they need? This building covers an entire city block. It's a big building. Why do they need so many court clerks? They're bank tellers. Mary, the head court clerk, Mary runs all the tellers. She's the bank president. She handles all the bonds. The federal courts buy all the state bonds. So everything that happens in the 9th district, which is California, Nevada, Oregon, Washington, Idaho, Montana, anything that happens in any of those state courts under the GSAs, the federal government buys them. The federal court buys them from the states. That's what funds the states.
Let's listen to that again.
The federal courts buy all the state bonds. So everything that happens in the 9th district, which is California, Nevada, Oregon, Washington, Idaho, Montana, anything that happens in any of those state courts under the GSAs, the federal government buys them. The federal court buys them from the states. That's what funds the states. And then they collect out of our trusts through the Department of Fiscal Services.
Okay, so to get this straight, so what he is saying, what it sounds like I'm hearing, is that the states get their funding by locking people up and creating other type of court acts or court procedures. So, the first thing cut in my mind is, the DMV, traffic. I mean, you got parking, you got, speeding, you got all different types of traffic type of violations, the vehicle code, right? Then the other things that you wouldn't think is considered traffic is considered traffic. So you have trafficking, right? And we're going to look that up too as well, what these words mean. The Black's Law Dictionary. I heard a brother mention about the Black's Law. Is it good for us? Is it useful? The Black's Law Dictionary is what it is, a dictionary. And it is for people to understand what these words mean in law and what words exist that you didn't think exist in law. I mean, I didn't know prescription was in a law dictionary, prescribe. You see what I'm saying? So a lot of these words, any other words that you might think that might be dealing in contracts or any other type of matter, is in a law dictionary. So that's what I'm seeking to clarify for people, because a lot of people understand that these words are just maybe basic words that really don't have any meaning past what people think the meaning is. But these words, most of these words, are in law. That's why they say everything you say can and shall be used against you. That's why you have Miranda rights, the Fifth Amendment, right? You don't want to self-incriminate But nevertheless, all of that, he said the 9th district, right? But actually it's the 9th circuit. The 9th circuit covers those areas, what he said. It might be also considered a district as well, but it's usually the 9th circuit, and that's the appellate court. That is the federal appellate court. So if you don't like the outcome of whatever is going on in court, you could take it to the 9th circuit on appeal. Okay? So that's what he's talking about. But, you know, that's some form of revelation right there, because that's a big part of what you would consider to be funding, revenue. So it's real interesting. Now, the other thing is what I'm focusing on is mortgages. So in those mortgages, right, you create what is considered a pooling account. A pooling account, securitization, real estate investment, real estate mortgage investment. You know, you have all a lot of all these instruments that get recorded in the county, right? So your deeds of trust, like in California, deeds of trust, grant deeds, all these instruments that are being, and they're commercial instruments at that are being recorded in the county recorder's office. That is supposed to be your record of deeds, or in all matters dealing with real estate. Right. On top of that, you're paying fees, you're paying taxes, you're paying, and you're depositing and you're tendering instruments in the county recorder's office. You tender instruments into the court, and all these things are related to the county. The county is ran by the board of supervisors. You have your county board of supervisors that cover all the different districts in that specific county. You also have city ordinances, municipalities as well. So, and their major cash cow is judicial court actions. And, you know, he kind of confirmed it right there. Never thought about it like that. That a lot of these issues are legal or lawful, or legal and lawful in nature. So your bank, it seems like, for all these states and counties are the courts. And the clerk is the banker, based off what he's saying. To me, it makes sense. And hopefully it's making sense to you guys, because what we've been going on, these definitions, it's kind of adding up a little bit. And some of these other videos that's kind of talking about this as well.
So those people are sitting there in their cubicles, typing on the computer, and they're filling out the SF 273, 274, and 275 forms all day long. It's a bank. So when these blue and white lights come on behind you, and you got that policy enforcement revenue collection agent behind you, who the Supreme Court says has no obligation to protect you. No, it's not their duty. It is not the police officer's duty to protect you. Their job title is a policy revenue collection agent. They're to help fund the counties and the cities and the state. They presume you're a citizen, a person, or resident. Your status agent.
Well, I guess there we go.
They're to help fund the counties and the cities and the state.
So there we go. He said it. Now I'm watching this for the first time. I'm taking this bit by bit. I saw some of it, but I really just kind of went over. I haven't really studied it, but I guess he just said it right there, that those people are to collect revenue for the city and the county and the state. So there we go.
They presume you're a citizen, a person, or resident.
Now, did anybody know that the California Highway Patrol, or CHP, runs the DMV? Anybody know that? I found out. I went to the DMV on Broadway, and I went in there, and, you know, that was having an issue with my paperwork or how I wanted things to be done. But when they called the police, CHP showed up. I was like, what y'all doing here? Ain't this supposed to be sheriff? I was like, no. CHP has jurisdiction over the DMV. Did you know that?
CHP got state police.
Yeah. So that's state police. See, I didn't know that. I just thought it was California Highway Patrol. Yeah. So there it is. So so he confirmed everything. There we go.
Your status. This is called status. Anybody know what status is?
Status. Let's go to status first. Let us go there first. Let's go to status first. Remember, I always start off here. Prescribe, prescription. Let's go to status. Oh, there it is. Let's go to status. What is the definition of status here? Let's see. He's been pretty much spot on. All right. So it says standing, state, or condition. So standing, state, or condition. Okay. Hold on. Let me check. All right. Nobody's in the back. Just making sure nobody's in the back. You guys gotta, what's up, you guys? You guys are here. You guys are late. But look, we got to get on this, right? So everybody's talking about status. Let's clarify status. It's going to get better than that, Rich. Standing, state, or condition. The legal relation of individual to rest of the community. Let's blow this up a little bit more. All right. The rights, duties, capacities, and incapacities which determine a person to a given class. Wait a minute. So status has to deal with a given class. Capacities, rights, duties, incapacities, which determine a person to a given class. All right. So we got white, black, we got all these different little things, right? So let's move forward. A legal personal relationship, not temporary in its nature, nor terminable at the mere will of the parties with which third persons in the state are concerned. So here we go. All right. We just reading it off right now. We don't know where this is going. Which the term, while term implies relation, it is not a mere relation. Now let's come down here. It also means estate, estate. Now remember, we're talking about mortgages, right? Remember what I showed you right here. This is a preliminary title report, Schedule A. Title to set estate or interest. So this estate is a status. What type of status is that? Okay, so we ain't gonna stay there. We're gonna come back. So said it also means estate because it signifies the condition or circumstances in which one stands with regard to his property. All right, so let's get back to him. Let's see what he says.
Did you know there was more than one? Jeez, they just didn't want you to know this crap, do they? See, in Title 8, Section 1101 of the United States Code, it says definitions of statuses. These are the definitions of status that the United States government accepts. right? You can be a U.S. citizen or a U.S. national or a state citizen or a state national or a variety of other things that they accept. But what are you taught? Just to be the one that they have control over. Isn't that crazy? It is status. They presume your status. This government works off of unrebutted presumption. Unrebutted presumption. They steal your house by making a lot of clerical errors and you don't correct them and you acquiesce. You just pay the bills and you don't correct those errors. And they stole it from you on behalf of the state. They steal your car when you go to the dealership and buy one by making a statement with the clerical errors that you fill out, you sign, you consent to, and then they stole your car. And you didn't even know it. You come home, you tell your family, look at my new car. Smell good, got that new car smell, so nice. It's the states. You don't have the MSO or the MCO. Now, they assume you did something wrong. You did 70 and a 55. Doesn't matter what it is. They assume you did something wrong. They get your tacit agreement of you being a citizen, a person, a resident. And then they get up on stand and they lie. And your attorney sits there and says, shh, don't say anything. We'll get our chance later. And then the hammer gets dropped and every lie that they said became truth and fact upon the record. You acquiesced to it. And your attorney knew that. He knows he's supposed to object to everything they say. And he sat there and he was quiet. And he told you not to speak because you can't. They can't hear you anyway. You know a judge can't hear you in court? No, they summons you into court. What is a summons? It's a seance. They're wearing black robes. This is satanic ritual. They summon you into court, a seance, calling the dead into court. And there's two ways for you to appear in court. There's only two. It's in the law. There's general appearance. That's where you just show up generally and you accept jurisdiction by just showing up. I get your tacit agreement of you being a citizen, person, or resident. You just show up. They call the dead into court and there you are. They call out your all caps name and you don't say, no, that's not me, Your Honor. That's my vessel. I take ownership of that vessel. I claim the minor estate. You don't say any of that. First words out of your mouth in a courtroom should be what? Okay, I'm sitting down in the back row. Judge walks in. Bailiff says, all rise. I lean back on my chair and I put my feet up. I sure ain't going to stand when he walks in. That's giving him jurisdiction. When an employee walks into the room, does this boss stand? No. He's my public servant. I have to take control of the court immediately. If you stand, you're the employee, he's the boss. He's getting your tacit agreement. You're turning over jurisdiction to him. Were you in Logan at Cody's?
All right. So that's status. So that's his take on status. Now, I agree with him in what he's talking about. In a sense, under the circumstances, try to get away in court without standing. You know what I mean? That's a whole different situation. Now, let's deal with this status in a state. Okay, so he's using a police officer for his example because it's easier to do when you got people sitting in front of you. Because everybody's been through a situation, not everybody, but mostly everybody has been through a situation where at one point in time they've been stopped or something like that, and they've talked to a police officer and been questioned. You know, but everything that has been set up at that point in time kind of makes you hesitant in regards to having that type of communication with one of those police officers. Now, when we deal with the estate, right? So we're right back here on estate. Okay. Now, we're going to go over to, back to fee simple. Where is that at? Let's go to, well, I thought I put estate in there too. Fee simple is cheap. Status, tender, donor. All right. Let's go to fee simple. All right, we're gonna go to fee simple. Right, we're dealing with fee simple here and dealing with estates. So how was they able to take you out of your status? If your status is already on record, how was they able to take you out of your status? Now, if you look over to the side, what he had was those things, right? Presumptions, assumptions, tacit, and then hearsay. Right? There's a case law that's called Trenzi versus Pagliaro. Trenzi versus Pagliaro deals with attorneys who present declarations or give testimony and evidence while in a position of counsel or in a position as an attorney. Trenzi versus Pagliaro specifically states that they cannot occupy two positions. They either going to be one or the other. They can't be both. But at the same time, you have a police officer that also does the same thing. He fills out a police report. He puts some presumptions and assumptions in there based on what this guy is saying, that we never rebutted those assumptions or presumptions. Right? So you look at it from that perspective. How was you able to be taken out of your, right? How was you able to take yourself out of this position of the estate or interest in the land? Your position in fee simple, right, is vested in you. The estate or interest, title to said estate or interest is vested in you. How is it possible that you all of a sudden have that done to you and you're out on your keister in a matter of minutes? Now, I'm just saying a matter of minutes figuratively, but you pretty much been there, and then you have all these instruments, but you got a bunch of people coming. You got not a bunch, you got certain people coming in, mostly attorneys, doing it in the name of a fictional business, right? Because all businesses are fiction because they can't speak. And they come in on behalf of that company, that business, that fictional business, and make declarations, make claims, complaints, and put things in the record. And then at the same time, you come in and then your voice is not heard. Now, it's interesting that he hit all the points that he's saying the judge can't hear you, can't even speak to you. Nothing is being said. Why is that? in that general appearance, if you do not come in by special appearance, it's a general appearance, and you subject yourself to that jurisdiction, and you don't even know what that jurisdiction is. You haven't put that on the record. So under those circumstances, there we go. Status. Status functions in every single capacity. Every single capacity. Status matters everywhere. Because we know that there is an estate there. Status is an estate. Now, if they putting you if they're trying to change your status and on the presumption, that means that they want to put you in a lesser class that has no status. Therefore, you're not competent enough, or you don't have control of what he says, the minor estate. So we're going to control it for you. And we'll just use you as the body in order to make the thing move in place and be able to monetize off of that. You'll just be there in your body. But everything is going to be used off all your instruments that are connected to you, that we're saying you have no control over because you're incompetent. So when you're dealing with estates, here, and this is in fee simple or fee, just like I showed you, right? We got fee here, and we got fee here, and we got fee simple to an estate and land, but term is actually applicable to any kind of hereditament. And is all the property and thing referred to or largest estate therein. Okay. Now we're going to go back here, 1656. We're going to go back to status. All right. And we'll come down here to estate. So status means estate status. So we come down here in this example down here, it says the status or interest in the land is a fee or fee simple. So the status of the interest in the land is fee simple. And that status is vested in whoever this person is. So we'll just say it's vested in you. That's your status. Your status is a owner of land. You're an owner with interest in the land, right? Because right here, remember, it says that this agreement made owner of whoever this person is, owner of the land. In a fee or I'm just connecting the dots for you. Fee simple. So if I do get pulled over, right? And I get stopped, they come up to the side of my window, I roll it down, quarter away, and I look at the officer, I said, "May I help you?" That's what I say. May I help you? What's the nature of this inquiry? Well, you were speeding past the speed limit. Oh yeah? Well, let me view that, the accuracy of that. Well, I need to see your license and registration. Oh, you do? Well, before I give you anything, I got a couple questions for you. Is that all right? Yeah, we're going to establish a relationship first. So when we go back and forth, I need to see your ID. I need to see your badge and your badge number. I need to see your ID. And you have a business card, I need to see that too. So now we're on a business, we're on a level playing field here. So when we're dealing with mortgages and they come in and they say, hey, we're serving you because you haven't paid on the mortgage, and we're going to be evicting you. Oh yeah? Okay, well, I need you to provide me, first of all, I need you to provide me any information that you have that we have some type of agreement that I gave you to evict me because of some payment that you say I owe you. Can you provide that for me, please? Now, this is even before we get to court. Now, most of the time, what they're going to do is they're going to ignore you after that. Oh, okay, we'll just circumvent and go straight to court on this. We'll go to the unlawful detainer division or the landlord tenant court, and we'll file these things. And guess what? The clerk is going to send you a letter or what they call a courtesy notice, right? They're going to send you a courtesy notice, right? A courtesy notice. They'll send you a courtesy notice, and they'll say, well, there was an unlawful detainer filed against you. And, I just want to let you know, once it happens, you got this time to respond, that time to respond. You know what I'm going to do? I'm going to send it back. I'm going to put it back in the envelope, seal it up, open by mistake, and return to sender. Then if they want to move forward with a summons, guess what I'm going to do? I'm going to package that thing up, put it in the envelope, and not even open it this time because I know where it's coming from, right back to sender. Excuse me, mailman, mailwoman, take this back. You try to send me something else, I'm sending it right back. That's how you stay out of jurisdiction. Now, if you know it's a place where you want to be and you want to be in that position, then you come in by special appearance. You come by special appearance. That's why you maintain jurisdiction. You don't submit to the jurisdiction. You actually just come in there and try to figure out what jurisdiction is. All right. So now, let's go to where are we at here. Let's go to estate. I thought I had that thing in there. We're going to come back to escheator, to escheat, but we're going to go to estate first. All right. So here's estate. The interest which anyone has in lands or in any other subject of property. Okay, that's estates. An estate in lands, tenements, and hereditaments signify such interest as the tenant has therein. All right. Now, this is interesting here because this says tenant. So it says an estate in lands, tenements, and hereditaments signify such interest as the tenant has therein. So now where does this stand here? Is that saying that the owner of the land is a tenant? Or is it saying that this instrument right here that created this is what you call lender's title insurance? All right. This is lender's title insurance. And the company is right there. The amount in the company right there. And it says, or successor in ownership of the indebtedness secured by the insured mortgage. So this title insurance insures that mortgage that was created. All right. But what they are recognizing is that this individual right here is the owner in fee simple of the land, but this mortgage and insurance policy also made her a tenant by transfer of title that states it in the deed of trust or mortgage, or that promissory note. All right. Now, this is where it gets complicated. But let me see if I can simplify this for you. Because status is everything, right? An estate is everything. But status and estate is the same thing. It's status. So where is your status at? Your status is as owner in fee simple. So that means you have control of the land. But that mortgage deed of trust also gave tenancy, not for you, right? But for that company that you see right here, or you don't see. This bank. This bank received tenement and tenancy as well, based on this indebtedness secured by insured mortgage. All right. So I'm going slow so you guys can kind of grab how I'm trying to show it. Now I'm about to give you another definition so this can make a little bit more sense to you as well. Now, let's see what else this estate says. The condition or circumstance in which the owner stands with regard to his property. So it says the condition or circumstance in which the owner stands. Owner is established. But the condition or circumstance of that mortgage in this insurance policy shows that the owner stands within this estate, or what they set up as the mortgage. This is a whole nother estate that was created, because the owner on that deed of trust is considered the trustor. Fidelity is considered to be the trustee, and that bank is considered to be the beneficiary. So that is a trust relationship. All right. In this sense, estate is constantly used in conveyances in connection with the words right, title, and interest, and is in a great degree synonymous with all of them. So even under the circumstances, that owner in fee simple just conveyed rights and title to that bank. And at the same time, gave them tenancy on that land. But the endorsement of that, because in that endorsement, it was blank. There was no endorsement there, right? There's no endorsement there. So this is the loophole. And it wasn't never negotiated. What does this mean? Title to said estate or interest at the date hereof is vested in a fee. What does that mean? Can you explain it to me? What rights am I giving up? Can you explain that to me? The deed of trust, where are we at? What am I waiving here? What am I doing? Rights and title, I'm conveying what over to you? Am I, at the end of the day, do I own this land, or do I own this land and the dwelling, everything on top, or no? You know, okay, so what are we doing then? So what we're doing is what you would consider to be, in investment terms, a double close. You have a purchase from the previous owner to you, and then at the same time, you're selling the house over to what? You're selling the house over to the bank, where the bank then becomes the beneficiary. That is what you consider to be a simultaneous close or a double close, and also a loan modification at the same time. Because the first initial loan, or an extension of credit, what you really should say, an extension of credit, was actually given to you to purchase the house. And at the same time, that dollar amount then was held by them because you never received a check. They kept it. They just opened up escrow. Then there's your issue. But no questions was ever asked. Nobody asked those questions. Unless, you know, you one of them that your deals and everything that you do, your lawyer goes handle that, and they get paid to do that. You know, I don't want to hear nothing. You make sure you protect everything, all my rights and everything is solid. That's what you do. That usually doesn't happen, especially in California. So in this definition, what it's saying what it is saying is that all rights, title, and interest is transferred. Now, this is making more sense now. I mean, because I still had some questions about it too as well. How is this figured out? Okay, so this title insurance policy is saying at this point in time that this individual owns the land in fee simple. And then through this mortgage and this indebtedness secured by the insured mortgage, this insurance policy is saying that it was just conveyed over to the company based on that mortgage. Because it says this right here, this bank right here, and the amount, and then it says, and any successor in ownership. Right? Oh, I wasn't sharing the goddamn screen. That show the fuck wasn't. God damn it. All right.
Grab me my hair. Shit.
All right. I wasn't even, God dang it. I wasn't even showing the dang screen. All right. So let's back up a little bit. Let's back up. All right, so here is the estate. Here's what we're talking about right here. In the sense, estate is constantly used in conveyances in connection with the words right, title, and interest. Okay, and then right here, what we have is the estate or interest in the land here and after described, referred to, covered is a fee. And right here it says successor in ownership of the indebtedness. So I just want to show you what this looks like. I apologize. I did that again. Didn't even put my screen back up. But yeah, so in this sense, so right here, the degree, quantity, nature, and extent of, hold on. In this sense, estate is constantly used in conveyances in connection with the words right, title, and interest, and it is in a great degree synonymous with all of them. So right here, this is what we're looking at right here. So they're saying this right here is a conveyance, and this conveyance was secured by the mortgage. So with this insured mortgage being presented, this deed of trust, this mortgage, rights, title, and interest was conveyed or transferred over to the bank. That's why the bank is the beneficiary. This fidelity is the trustee on the deed of trust, and this individual right here is considered to be the trustor. Remember, we looked up what trustee is, fiduciary is. It is responsible for payment, it is responsible as a duty. Okay? So this is what we look at, but nobody asked the question. You know, we don't ask those questions. Now, I think if anybody knew that this actually said, okay, as soon as you get this loan, or as soon as you buy this house from the previous owner, you're now through this mortgage selling the house over to me. You see? Now, let's come back. I apologize. Dan, that messed up my flow right there. I ain't even have this thing showing. Nevertheless, it's one of them days, I guess. Okay. So, in another sense, estate designates the property, real or personal, in which one has a right or interest. Okay, so in this one, it says interest. The subject matter of ownership, the corpus of property. So that's the body. Corpus is usually body of property. Thus, we speak of a valuable estate, all my estate, separate estate, trust estate, etc. This also is its meaning in the classification of property into real estate and personal estate. There is no such legal entity as an estate. It is a convenient phrase to identify the subject of litigation in the orphans' court and in proceedings in rem. You remember when this guy said they can't speak to you, right? Can't speak to you. This is what we're talking about, in rem. We're going to go to in rem. We'll go there so we can take a look at that in rem and to show you what exactly that means as well. Right? So, and in proceedings in rem, it may be treated as harmless, superfluity, but as a designation of a party to be served with a writ, it is unknown to the law. It cannot be made the plaintiff in an action, as it is not a person. It cannot sue or be sued. All right. Now, we getting somewhere. I mean, this interesting. Interesting. This is why we're here. I've always, let's go to in rem. Let's go to in rem. All right, here it is. All right, so in rem, a technical term used to designate proceedings or actions instituted against the thing in contradistinction to personal actions, which are said to be in personam. See, in personam. It is true that in a strict sense, a proceeding in rem is one taken directly against property and has for its object the disposition of property without reference to the title of individual claimants. So, status. So when they're doing something in rem, that means what? You're not there. They're pretty much saying that we have control of this property, or you have control of this property, court, through the county, through the registration of those instruments. You have subject matter jurisdiction. You have a form of a lien. They pay property taxes, everything. You have jurisdiction. You have a form of an encumbrance or lien based on that fact. And we need you to exert your authority over them because you have a part of their estate. So what I'm gonna do is I'm gonna create all these legal fictions, presumptions, assumptions, like this man said, presumptions, assumptions, tacits, and hearsay. But we got to make it a guise under the proceedings that it is something that is not. So as soon as we bring them into this trap or into the lion's den, we got them cornered. They're going to be arguing, they're going to be exerting rights and everything like that. But this, we already know that this is not the subject matter jurisdiction they're dealing with, because now we got them in here as a tenant and not an owner. You see? Now, under the circumstances, this is where, you know, everything gets tricky. Now, I'm just putting this out there to think about things that you could possibly do to correct your status. Right? Because in these same documents, right? In these same documents, right? In these same documents, all these documents are tied together. In these same documents, it says right here that no contact was made with the borrower because the loan is not secured by a first lien mortgage or deed of trust that secures a loan or that encumbers real property. So if that's the case, how are you able to bring a claim? But that's what they want you to do. They want you to come in and argue. They want you to come in and participate in their theatrics. Now, let's go down. Let's go to in persona. Okay. We have in rem against the thing. Right? It's against the thing, not individual claimants. No claimants here. So, no claimants taken against the thing or against property. And for its object, the disposition of property. So let's see where in persona comes in. Okay, in personam, in rem. Okay, so it says in the Roman law, from which they are taken, the expressions in rem and in personam were always opposed to one another. An act or proceeding in personam being one done or directed against or with reference to a specific person, while act or proceeding in rem was one done or directed with reference to no specific person. And consequently against or with reference to all whom it might concern or all the world. The phrases were especially applied to actions and actio in persona being the remedy where a claim against a specific person arose out of an obligation, whether ex contractu or ex maleficio, while actio in rem was one brought for the assertion of a right of property, easement, status, etc., against one who denied or infringed it, who denied right of property, right of easement, right of status. How can a lawyer come in there on behalf of a company, a business, a bank who cannot own real property, especially single-family residentials, from 1 to 4 units? What right do they have? Who is claiming the right? It's impossible. Now, in propria persona, in one's own proper person. So, now, let me see here. Okay, now, where the 818? 818. Now, fee simple. A fee simple absolute is an estate limited absolutely to a man and his heirs and assigns forever without limitation or condition. Okay, so you would say this right here is not absolute fee simple. It's not absolute. Conditional. At the common law estate in fee simple, conditional way was a fee limited or restrained to some particular heirs, but the status, okay, but yeah, okay. An absolute or fee simple estate is one in which the owner is entitled to the entire property with unconditional power of disposition during his life and descending to his heirs and legal representatives upon his death. Intestate. So when we look at the entirety of what we're dealing with in regards to any type of reparations and restoration and restitution in this matter, status has to be identified. Status had to be made on the record and corrected if everything was done in contradiction to it in order to do something to make sure that man or that woman, you know, retains or is restored to their proper place, which is their land. Because you would actually see that there's absolutely no language that mentions land in any matter dealing with foreclosures, evictions, and all the other things. Land is never mentioned. All right. Now, boom, boom. All right. So what we're going to do here, let's come back. Let's listen to some more.
Deal where we had about 60 people there. Okay, we had about 60 people in Cody Smith's court case in Logan, Utah. And I met with everybody before we went. And I told them, not only do not stand when the judge walks in, but I want you to make a concerted effort to lean back and put your feet up. And they did. There was only one reporter on the other side that stood up. Nobody else did. And then in one voice, when they started running over the top of Cody, we all said, let him speak, in one voice. and Cody got to speak. The entire court changed. What I tell people is rally the troops, get them in there on your behalf. If you can get at least 25 people in the audience doing what I'm just telling you to do, when you stand up there, say, I'm here by special divine appearance, Your Honor, to call for a constitutional court of record, and I brought a grand jury with me.
Of my peers.
What is the definition of peers?
Like-minded individuals.
No, here's one that's really got screwed up by our bar association. When you call for a jury trial or a trial by jury, what's the difference? Do you guys know? Always call for a trial by jury. Why call for a trial by jury? But the trial by jury, the jury decides your fate. A jury trial, the judge can override the jury's decision and do whatever he wants. And they will try and force you into a jury trial. They will.
Now, under the circumstances, I had mentioned that yesterday. But in order to get a clear idea of what we're going to do more in the advanced classes, right? I would say these advanced, classes, seminars, such. We're gonna do more like I did earlier, just like a little role playing here. How are we going to be able to correct our status in our contracts, in our consumer credit installment contracts? How are we going to be able to correct that? How is the proper way to do it? Not the microwave way where you say, well, I'm disputing the status, I'm disputing the validity of this debt. No, we're going to do a complete, itemized, Freedom of Information Act and Public Records Act, whatever state you're in. What we're going to do is we're going to cover every aspect of the government. That is legislative, executive, judicial. And then we're going to deal with what? Commercial, contract, consumer laws. And then we're going to deal with the acts that come with that, because a lot of people like to use the title codes, but you need to use the act as well. The acts came first, and they produce codes. Okay? And we need to know which ones we're using when we're dealing with some of these entities. We also need to know where these entities are, who they're regulated by, and who is their oversight, which you have oversight. Right? For an example, you got the comptroller of the currency. Who are they the oversight for? You have the Federal Depository Insurance Corporation. Who do they regulate? You have the Federal Reserve Board. Who do they regulate? You have the Security Exchange Commission, Securities and Exchange Commission. Who do they regulate? You have the Fair Trade Commission, FTC. Who do they regulate? You have the Consumer Protection Bureau. Who do they regulate? You have the Treasury. You have the United States Treasury. Who do they regulate? Everybody. You have the Internal Revenue Code. Who do they regulate? Okay. You have a lot of these different avenues of places where you have multiple causes of action, multiple claims. What is the difference between a claimant, a plaintiff, or a complainant? Complainant, claimant, right? What's the difference between a defendant and a respondent? What is the difference? Those are the things that we need to understand in order to make a valid claim. Fair credit, fair debt, truth in lending, those things are good, but they're not everything. Those things are avenues within the bigger umbrella, right? You have the Real Estate Settlement Procedures Act, Frank Dodd Act. I think I'm saying that right. You have all these different things that are very important. So in a mortgage, we have covered the fact that there's promissory note, bill of exchange, there's special and blank endorsements, there's conveyances, there's insurance, there's estates and interests, there's a grant deed, there's a conveyance from the previous owner to the new owner. Then obviously there's a deed of trust that's set up. There's a trust deed. There's a trust that's set up as well, where you have a trustor, trustee, and a beneficiary set up. Right? And then we have that same bank now. We have discovered that the same bank that is the beneficiary is not even really a beneficiary or a lender or a creditor. They're more or less just a servicer. Now, we know the definition of a servicer, somebody that provides a service. And what is that service? Right? So we have creditor, we have a debtor, we have a lender, we have a borrower. We have all these different things. We have a taxpayer, right? We have taxes that are involved. We have consumer issues that are involved. We have contractual issues that are involved. So there's a lot to cover. How do we cover all those things, right? There was escrow. There was actually payment. There's a receipt of that. You have a lot of different things. You really think that is just stuck in consumer law? How do you cover them angles properly? This is what we need to kind of go over. And once we get into I'm giving you the boring stuff. This is the boring stuff. I'm sorry. It's the boring stuff. I got to do it. I just got to do it. Got to do it. But we have to go over those things so we get a clear idea what these meanings are. So when we get to it, now I'm going to set up some things. I'm going to redact some names. I'm going to show you some stuff that I've done. I'm going to cover the names. I'm going to show you actually in the responses what I've got from the letters that I sent out. And I'll make them like a template type thing. So we'll take names out. You'll see what was done. And then you'll see the actual response that was given. They will tell you everything that you need to know. It's just about how you go about doing it. Now, it's not really, I mean, this is, I wouldn't even say this is not for the faint of heart. I would say this is more just for the patients. Those that have patience, those that are willing to run the marathon, those that have endurance. Because it's the process. I mean, you're going to have to do some accounting. You're going to have to download forms. You're going to have to get these letters together. You're going to have to go buy you some stamps. You got to go get you some certified mail slips. You got to get some return. You got to get a stack of return receipts cards. You got to get some register mail slips. You got to get a firm book. Well, you really don't have to get the book. They actually have it where you can do them individually. You have to get a lot of different things going on, and you're going to have a little money because a lot of these things have to be insured. You have to set up a relationship with your local post office. You know, you're going to have to get a post office box. You're going to have to, you know, possibly see how you can set up a bank account. You know, you're going to have to do all these things because you got to secure your assets. Your assets are out there floating and unsecured. You're going to have the accounting is, I say the most important thing that's going to be tedious is the accounting. Because you're going to have to go all the way back to the beginning. You're going to look at everything that was done. You're going to have to go to the recorder's office, county recorder's office, where they record the land records and all this stuff. You're going to have to go from the day you got the property or the land and you bought that, you got to get a breakdown. Easiest way to do it is to get a title report. Talk to a real estate agent that you know or somebody, or go to a title company and say, hey, I need a title report from this date of the grand deed. I need a full title report. Yeah, I need the preliminary title report. I need everything. And the best thing to do is go to the actual title company that actually, you will know who the title company is based on your deed of trust. And this is why a lot of the title companies, you won't find them on deeds of trust anymore as trustees after the 2008 situation, because these title companies was insuring all these bad mortgages. See what I'm saying? But you want to go back to that entity, and most of those title companies are attorney firms. They're mostly all attorneys. So that's what you're going to need to do. And hopefully, you know, if you're listening now, listening later, if this is what you're really trying to accomplish, I think this is why you're here, is those things you need to have. Now, you might not have nothing, but, you know, mother and father or whatever like that, or, you you might want to get that information if they're here, or even if they're gone, definitely. But even if they're here, you want to kind of stay in the game a little bit. Talk to them a little bit, say, hey, you got everything secured and everything, so on and so forth, and make sure that if they don't, that you say, hey, I've been studying this and I've been studying that, I would like to be able to help and see if we can make sure we got everything secured, and at least, go over the accounting of everything to make sure that everything is above board, And that question is, hey, you got your original grant deed? That's the first question. They might be like, yeah, I do. Oh, you got it? Where's that? Pull it up. Here it is. It's the first one I ever had. Where's your original signature at? Where's the wet signature at? Wait a minute. Yeah, I'm supposed to get the original? Yeah. That's supposed to go from you, from the grantor, the previous owner, to you. You're supposed to have the original. Who got it? Well, let's see. Yeah, that's who got it. The one at the top. That's where it was sent to. Yeah, you still got that information? Well, I think, maybe we should go give them a call, ask them where your original grant deed is at. You should have it. Now, the other thing, do you have your paperwork when you first got it? Most older cats, they got their paperwork. Yeah, I got it. You got the preliminary report, everything, the title report, everything you did at closing. Yeah, I got that. Pull that out. Let me take a look. Yeah. Oh, see that Schedule A right there? Yeah, I learned that. That shows who's the owner. Fee simple. And this is an insurance, title insurance, on a mortgage, and this other company's insured. Are you still paying that company? No. Who are you paying? They're gonna start thinking, the older, the parents, when they talk to their children, they don't show a lot of emotion. They just get a little quiet, be like, they'll go, yeah, I'm just something to think about. And they'll play it off. Oh, yeah, okay, yeah. That ain't nothing. Yep. I knew. Yeah. They'll play the I know game. And then they'll be thinking about it. Yeah, I'm just saying, get all these affairs in order because you don't even know who you paying. Do you got any letters from them saying that they was going to be taking over the payments and all that? And what their status is? Because that other company said that they lent you money, right? Yeah. They lent me the money to get the house. They did? Well, if they lent you the money and they no longer are accepting payments, then who are these people? They ain't lend you any money. They ain't lend you any money. Huh. And the parents go, interesting. Then they'll keep a straight face. They'll play it off. But I guarantee you when they walk away and you leave the house, they're going to be like, hey, you know what Coach just told us? Aton just told us this. Yeah, I think we need to look into that. They sure will look into it. And that's the start. That's how you do it. Simple. No soapbox, no preaching, no nothing. Say it just like that. Now, in the circumstance, then, once all that comes, because they're going to probably call you. Or they'll wait till the next time they see you come, you have that conversation, then they'll be like, okay. Might be them. Oh, yeah. Yeah, let's go over. You got the deed of trust too? You got that original deed? You got that deed of trust you had at closing? Yeah. What I'm gonna do is I'm gonna go to the county recorder and I'm gonna get a certified copy of the original grant deed. No, I'll just get a regular copy because certified gonna cost a lot. I'll just get a printout. I'll just get a printout of the deed of trust and let's match it with the one you had at closing. Watch, it's gonna look different. You don't tell them that. You give them the surprise. Watch, it's gonna look different. And they're gonna say, wow. Do you have the original application? The loan application? Yeah, I got that too. Yeah, I got that tucked away. Yeah, let's take a look at that. Interesting. Now you're getting into, well, they're not tripping off nothing because, yeah, they make their payments. They nothing bad standing, ain't good standing, make their payments. Like, look, I'm just trying to let you know so that way, if there's any questions you need to ask these people, so that way you're clear on what's going on, then, if you want to dispute it or if you just want to go along with it, then, I've been doing some studying, just some basic stuff that we can just figure out how we can actually, kind of dispute this. If you want to get a lawyer or something, or somebody that might be able to, check with the credit reporting agencies and, check with your consumer rights and making sure that everything's above board. And these people have the right to, these people have the rights and entitled to enforce payment on you. You know what I'm saying? We get that right, we good. Best case scenario, your debt is over with, mortgage is over with, it's done. Now, the other thing is that, they've been sending you 1098s and things like that, tax issues. It could also be a tax issue as well. You see what I'm saying? Under the circumstances. And, with that, you might be able to get a refund too. I've been studying some stuff. Oh, yeah, okay. You've been studying. And then, once you get into that place where they get comfortable, they can move forward. And eventually, you know, you got people like that, you know, they go to an attorney and say, hey, you know what? I want to file a quiet title action on these people. I want to do an action. I want to do a quiet title action. You know, if you got an accountant, you say, hey, I want to get an accounting done, a forensic audit done on this mortgage and this securitization. I want to get an audit on this thing. How do I go about doing that? Oh yeah, we can help with that. I got somebody in Bel Air. They can help with that. Yeah. We're not just going to mortgage the audit with the SEC, the Security and Exchange Commission. We also going to audit it through the Treasury and the Internal Revenue Service. We'll have them audit that for us, so we can actually see what's going on with this stuff. That right there, the elders can understand. Simple, plain, and they get it. So once you do all your exhaustion of your remedies and communications with these people prejudicial, these people in these corporations prejudicial, then once you come into court, you already got summary judgment on the table. They never responded. So I need judgment. They're going to give them an opportunity to say, hey, why haven't you responded? Why didn't you provide them anything that they needed? Then they'll say, well, and then they're going to say, well, you have 30 days to get that to them. If you don't, I'm going to be forced to rule in their favor. But most of the time when you do have the right approach, because I kind of perfected my approach, more is less, what they like, you know, I was told in sports. More is less. In other words, don't do too much. When they say you're doing too much, you ain't got to do that much. Simplify. Less is more. More is less. You got it? So we get right to the point, get right to the information, what we needed. We cover all the aspects of law and legal. Legal, lawful. Because if you don't provide these things to me, now we get to the unlawful segment where you now are possibly doing something very criminal in nature. And now you have access to any jurisdiction you want on any count and claims that you want to have. Because remember, it's a claim. It's not a complaint. Now let's do this real quick while I'm thinking about it. Let's go to petition. Let's come down here to petition. Oh man, that ain't what I wanted. All right. Let's go to petition. We're going to start with petition. We're going to go to complaint, and then we're going to go to claim. Petition, man, petition. It's taking you so long. All right. Petition, right here. I'll close this real quick. Let's close this real quick. Petition, a written address embodying an application or prayer from the person or persons preferring it to the power, body, or person to whom it is presented. to the power, body, or person to whom it is presented. So when you send a petition, when you're petitioning somebody, that means they have the power to hear it. Not the power over you, but the power to hear it. It is the competent jurisdiction thereof. All right. To whom it is presented for the exercise of his or their authority in the redress of some wrong. All right. Or the grant of some favor, privilege, or license. In practice, an application made to a court ex parte, or where there are no parties in opposition, praying for the exercise of the judicial powers of the court in relation to some matter which is not the subject for a suit or action. Or for authority to do some act which requires the sanction of the court, as for the appointment of a guardian for leave to sell trust property. Now, remember when we looked up in rem and in personam, and also think about when I said, once you exhaust everything prejudicially with prejudice, right? With prejudice, before you come before the judge, before you get to the court. Once you come in there, I exhausted everything. I'm petitioning this court to give me summary judgment right now. All right, so the word petition is generally used in judicial proceedings to describe an application in writing, in contradistinction to a motion, which may be viva voce, whatever that means. And we got to look that up. Dang it. We got to do it, y'all. This is what we do. We just don't leave a word out there. The principal distinction between motions and petitions lies in the fact that motions, though usually made in writing, may sometimes be made orally, while a petition is always in writing. So also motions can usually be made only by a party to the record, while petitions made in some cases be presented by persons not parties. So let's go to viva voce. Viva los viva. 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 All right. Viva. 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 T-U-V. Oh, here it is. With the living voice. Okay. By word of mouth, as applied to the examination of witnesses, this phrase equivalent to orally. All right. It is used in contradistinction to evidence on affidavits or depositions. All right. Now, and then we out of here. Let's go to, get up here. Let's go to complain. All right, here we go. Complaint. Uh-oh. Complaint. Complainant. One who applies to the courts for legal redress, one who exhibits a bill of complaint. So here we go. A bill. This is the proper designation of one suing in equity, though plaintiff is often used in equity proceedings as well as at law. One who instigates prosecution or prefers an accusation against suspected person. Complaint. In those states having a code of civil procedure, the complaint is the first or initiatory pleading on the part of the plaintiff in a civil action. It corresponds to the declaration in the common law practice. Now let's go to claim. All right, claim. Here we go. Claim. To demand as one's own, to assert, to state, to urge, to assist. That's the claim. May embrace or apply to a call, a demand, a pretense, a right or title. There we go. An account. There we go. That's where we want to be. That's where we want to be. That's where we want to be. So, yeah, we're going to leave off right there. We're going to come back with that, and we're going to now get into this. So, listen, y'all. We're going to get into some of these things. We're going to do some things in practice. I just got to get my redaction on. It's a lot, but I got to get my redaction on. Hey, but from that point of nature right there, hey, we're going to cut this one short. And we are going to get up out of here, man. We are going to get up out of here. We'll just do a short one. You know, I'll be keeping y'all real long, so we'll do a short one. And I think we got off to a pretty good start. And, you know, I know some of my stuff be kind of boring, you know, because I'm doing, you know, I'm pretty much taking the steps, but I want you guys to get these definitions proper, understand them a little bit, and then we go from there. But until then, when this song is over, it's over. It is over. Appreciate you guys being here. Hope you guys hit the like button, share it out, repost it. This was a simple one. It's a simple one. But we're getting somewhere. It's a lot of power in these things. Just take your time. It's a marathon, not a sprint, brothers and sisters. To the next one.
Don't move it. Don't move it. Don't move it. Yeah. Don't move it. Don't move it. Don't move it.
I'm the coach, quotes coded in oak with a ghost loaded focus. Chrome in the coke, king with the cloak, smoking that hocus pocus. Infinite styles, pivot and pile up the mileage. I'm wild with the science. You see the line on my avatar, iron jaw pride. I to devour the silence. Why you niggas steady lying? Got me laughing hard, satire and fraud. I fire the squad. Wise get crossed when I'm sparring with all the guards. Author of art, carving a mark in the bark of the market at large. Target the sharks, heart of a Spartan. I sharpen the margin with bars. You rather bargain and dodge. I'd rather you come get your taxes done. Black suit back, room facts in a stack. I'm relaxing the maximum. Get out of the pocket, the profit of rocket. Then I just might tax you punks. Bracket your funds, I'm stacking in chunks. Reacting to acid, you're begging a punch. Sometimes my community hard-headed, scarred, dreading the lessons. I chart head and start spreading the message embedded in pressure. Sovereign living, I'm private with it. No corporate percentage. Discharging debt with a pen stroke. You still don't notice the vision. I've been telling y'all you don't want to debate me. Weighty and ready. Great with machetes, linguistically shredding the petty. Grab these 15 acres. Landscape major, plan made paper. Land patent stamped and sacred since my campaign greater. I ain't talking about Ice-T when I say that I can show you law and order. Court recorder, I sort the torture, contort the border. I eat the case, beat the state, leave a trace of the raw supporter. Briefcase aura, got your baby mama thinking that I'm a lawyer. Seminole Indian sentiment, militant on Summer and Sawyer. Private enrollment, tribal component. I'm the boss if you're trying to employ it.